Good morning and thanks for joining us for a Tax Practitioners Board webinar. My name's Lun Lak and I'm joining you from Gadigal country. I respectfully acknowledge the traditional owners and custodians of country throughout Australia and their continuing connection to land, waters and community. I would like to pay my respect to them and their cultures and elders past and present. To begin, I have a few quick housekeeping messages. First, to obtain a copy of today's slides, you can visit our webinars resource hub at tbb.gov.au/webinar-hub. We'll also email you a copy of the slides. Today's webinar counts towards your continuing professional education or CPE, and you can claim 1 hour for attending. In relation to claiming your CPE, we will issue an attendance certificate to those staying on for the duration of the webinar. Today's format is a bit different from our usual webinars. We'll be providing a quick overview of the code determination obligations before opening the session to you to ask questions in relation to your new obligations. To ask questions, simply type your questions into the Q&A. And to find the Q&A, simply hover your mouse over the screen and a range of icons will appear on the bottom of the screen. You can also use the chat function to speak with other participants. But if you do need a response from us, be sure to use the Q&A. And also to disable any of these functions, simply hover over the relevant icon and unselect Show Preview. I also want to note that we have a lot of people online today, so we may not get to all of your questions. However, we will answer FAQs via our webinar resource hub. So keep an eye on our website and we'll share responses to the commonly asked questions there. Also, a reminder to keep your comments courteous and professional. Now, I would like to introduce our speakers for today. We are joined by TVB board member, Kerry Sadiq, and the TVB's Director of Policy and Legislation, Tariq Kumar. Welcome to you both. I'll hand over to you, Kerry, to kick things off.
Thank you very much, Lon, and welcome to everyone who's online. I can see we have approximately 3,000 people currently listening. So as Lon said, today's webinar format is slightly different from our usual webinars where we present. We really want you to have this opportunity to ask us questions, and hopefully we'll get to most of those questions. Now, before we do that, I thought I'd provide you with a quick overview of the code determinant obligations before I open up the session for questions. And as Lauren said, we simply ask you to type your questions into the Q&A and we'll curate those and have a look at which ones are coming up regularly. Now, moving on to what is the code determination. I know a lot of you have attended webinars previously, so some of it is old ground, but because of the way the code determination worked, we had it coming into effect for the large practitioners of more than 100 employees on the 1st of January. But I imagine a lot online today fall within that smaller firm category with 100 employees or less, so it only commenced on the 1st of July 2025, only a couple of months ago. So for those of you who haven't spent much time on the topic yet, I'll walk you through the various code obligations, but rather than just list them as to how they work, I'll embed some of the standard questions that we've been getting. So I'll preempt some of the questions that I'm expecting you to ask. So let's get started. By way of background, we know that the Minister, in our case, the Assistant Treasurer, issued the determination on the 9th of October 2024. So it's still very new, introducing 8 code obligations to supplement the existing obligations under the Code of Professional Conduct, and what we always refer to as the code. Now, the thing to keep in mind at the outset is that these code obligations are consistent with the existing 5 key principles of the code. So things like honesty and integrity, independence, confidentiality, competence, etc. They're also very consistent with the requirements of the International Accounting and Ethics Standard Board and the general requirements of the larger accounting bodies or professional associations that many of you are members of. And we know also that during the consultation process, it was decided that it was appropriate to have a transition period, hence the reason that many of you are here today having it come into effect on the 1st of July. Now, through the introduction of these changes and through our own work, we at the outset have been making it clear that we take a pragmatic and proportionate approach to the implementation of these changes. And because they are in effect for all practitioners now, we are still doing that. So keep in mind, as I'm talking, overarching this conversation for you is our obligation as the TPB around consumer protection. And what we're looking at is professional and ethical conduct. So all of these obligations do relate to that. And in the implementation, we're looking at a proportionate and appropriate approach. So what is relevant to you? And this webinar itself is entitled, helping you succeed. So that's what we're trying to do. So I'd like to now go through the 8 obligations very briefly. And as I said, I'll build in some questions that we're expecting that you may ask. So the first one that we have is upholding and promoting ethical standards of the tax profession. Now, what we expect under this obligation is for you to be independently and in cooperation with other tax practitioners upholding and promoting the code. So it means that you don't engage in certain behaviour. You don't engage in conduct that you know or reasonably to know may undermine the public trust and confidence in the integrity of the tax profession. So conduct that discredits the tax profession and brings the tax profession into disrepute or undermines public trust and confidence in the integrity of the system overall. Now, the question that we get asked around this is, well, what can we do and can't we do? So what we're really talking about here does prevent you from engaging in genuine and respectful debate about the tax system. So as I was saying, this upholding and promoting ethical standards of the tax profession, it doesn't prevent you from engaging in genuine and respectful debate about the system. It doesn't restrict you from involvement in any genuine political activity. It's what people were worried about initially. But what we're really saying is don't be involved in tax schemes or any deliberate evasion or avoidance of tax obligations. That will breach this particular obligation. So ultimately, if you've got questions around what you need to do to comply with this standard, is that engage in behaviour that promotes trust and faith in the tax system. So moving on now to false or misleading statements. Again, a sort of practical summary on what this requires. As most of you know, not making false or misleading statements has been a pillar of how our tax system works. So these new requirements just make it a little more specific about what has to happen with your own involvement with these statements. So there's 2 elements to this obligation. The first requirement is that you must not make a statement to the TPB, commissioner or other Australian government agency, or prepare a statement that you know or reasonably to know is likely to be made to the TPB, commissioner or other Australian government agency by an entity. Or you must not permit or direct someone else to make or prepare such a statement that you know or reasonably to know is false, incorrect, or misleading in a material particular or omits something. So again, what this standard does is highlight the importance of your role in the tax system, particularly when making representations to the TPB or the commissioner. Now, that standard is entirely consistent with Code Item 1, which is around honesty and integrity. So it's just building on what we already know and being more specific. Anything that's trivial will not constitute a breach of the code obligation. So if there's no flow-on effects to the statement being made, then it will be considered trivial. The second aspect is that the obligation requires you to take certain further action where a statement has been given to the TPB or commissioner. And at a time after the statement was made, you have reasonable grounds to believe that it was either false or misleading in a material particular at the time the statement was made, or omitted a matter or thing that was misleading. So what happens? Most questions here we find around what do you do if a false or misleading statement has been made and you discover it? Well, you then have a reasonable period of time to take certain additional action, and that could include having the statement corrected or advising your client to correct the statement, potentially notifying a TPB or ATO about the matter. So we encourage you, once you know a statement has been made that is false or misleading, to have it corrected. And the idea is that, again, we want you to engage in professional and ethical conduct. So correcting the information displays the goodwill of the tax practitioner. And that's certainly factored into any of the kind of sanctions that the TPB would take. So a really simple example here that I'll give you is that you might have an employee who is a registered tax practitioner. They've ticked a box saying that they have personal indemnity insurance because they thought their employer's policy covered. It turns out it didn't cover it. So what do? You just fix it. You fix the problem and then you notify the TPB, you have it rectified. Would we take any action in that case? We may simply issue you a notice saying that you've notified us, and that will be it. That will go on the record to cover everyone off, to say it's been rectified. We wouldn't take any particular sanctions in that case, apart from a caution, a simple caution, which everyone knows it shouldn't have been done. Okay, moving on to conflicts of interest in activities undertaken for government. I'm going to spend only a very short time on this one and the next one, which is maintaining confidentiality in dealings with government, because these only apply if you are actually engaging with government consultations or activities with a government agency in a professional capacity. Now, most of you probably won't have these two standards apply because you simply won't be engaged by an Australian government agency to undertake an activity for that agency. If you're not undertaking those, these obligations simply don't apply to you. If you are undertaking some kind of activity with a government agency, it simply requires you to take reasonable steps to identify and document any material conflict of interest, whether it's real or apparent, that you have in connection with the activity. So you disclose those details, and then you take reasonable steps to manage, mitigate, and where appropriate and possible, avoid any material conflict of interest. Now, you don't have to step aside. It doesn't mean you can't engage. The obligation is around documenting and dealing with that conflict of interest. It creates an obligation to manage and mitigate the conflicts, not prohibit you from having the conflict. So that's the first one, which is conflicts of interest in activities undertaken for government. The second one that is related is maintaining confidentiality in dealings with government. So again, it's only if you're dealing with government that you're going to have this potential confidentiality question. So it simply requires you to not disclose information received directly or indirectly from a government agency in connection with any activities undertaken with that agency in your professional capacity, unless there is a legal duty to do so or you're authorised to do it. So again, the obligation is intended to protect against the unauthorised disclosure and improper use by registered tax practitioners of information they obtain in relation to activities they undertake with a government agency. We do tend to get questions on this particular requirement around how far you can talk about the information within a firm. So if you're consulting with government and they're seeking your advice, go back to your colleagues and also ask for their input. We always advise to exercise caution here, unless you are specifically given authority to do that. The simple answer is no. So the confidentiality is with you. So you can't then go out and speak to other people in your firm unless you are given permission, you're authorised by that agency for further disclosure. So always exercise caution in that case. The next one is keeping proper client records. So this particular requirement requires registered tax practitioners to keep records that correctly record the tax agent services they have provided, or which are provided on their behalf to each of their clients. So in practical terms, to answer a lot of the questions we've received around this particular obligation, it's about substantiating the quality and accuracy of the tax agent's services that you are providing so that we know that you've made the correct decisions. So again, it gets back to that professional and ethical conduct. We're looking to see that you've provided tax agent services competently and professionally to your client. That means we don't require full ledgers, but rather how you came to certain positions. So the requirements are that the records are in English, retained for 5 years, which is the standard timeframe for record keeping prescribed under the Australian tax law, that they show the nature and scope and outcome of the service provided. They reference information reasonably considered in the provision of the tax agent service. And we've had questions around that particular requirement in relation to ATO information. So if you've got private rulings, make sure you keep them. And we also suggest, we've had questions around ATO information on their website. We all know the ATO updates their website and their information regularly. We know it changes over time. We always recommend, if you are relying on that information, take a screenshot, keep it on file. It's as simple as that. So just keeping a record of how you came to the advice. You also need to include all advice received from the client and advice provided to the client. So, and then obviously there's a question around complexity as well. So for more complex matters, the relevant facts, assumptions, and reasoning underpinning any advice provided should also be kept. So this obligation, most of you will, I imagine, all of you online will already be complying with, but it's keeping clear evidence of your actions and clarifying what actions have occurred or advice has been provided. And it protects you as well. And as I said, this webinar is designed to ensure that you succeed. And keeping proper client records is particularly important when disputes or queries arise. The next one is tax agent services provided on your behalf, provided competently. So this particular obligation ensures tax agent services are provided competently and means that tax practitioners must ensure each entity providing services on their behalf maintains knowledge and skills that are adequate and relevant to the services the entity is providing, and that it's adequately supervised. Now, where we get questions around this one is outsourcing and offshoring. So we've had questions previously, are the same obligations imposed when services are sent offshore? And the answer is a resounding yes. This obligation applies no matter where the services are sourced. Now, this obligation, again, is just consistent with existing obligations around competence and a sufficient number of supervision requirements, supervisory arrangements. So what does that mean in the negative? What do you actually need to do as a tax practitioner? You need to ensure that those services are provided competently. It doesn't mean that every one of your employees is required to have detailed knowledge and skills in relation to all the services provided to you. It's the tax practitioner that needs to ensure that their employees or the outsourcing, offshoring services have the knowledge and skills appropriate to the services that the employee is providing on your behalf. Now, that often results in questions around the level of supervision, and that's a question of fact. What is appropriate for your particular entity? That's going to come down to the services being provided combined with your system of controls. So, and we're going to talk about quality management systems in a minute, but here, quality management systems checklists are going to assist you in ensuring that those services are provided competently and that your obligation is being met. But just do keep in mind, because as I've said, and I'm starting to repeat myself, I apologize, but we have been asked numerous times around offshoring. The same obligations do apply. So I'm moving on now to your QMS. And I said I was going to talk about, there is a requirement there that all registered tax practitioners must establish and maintain a system of quality management in relation to the services that they provide or are provided on their behalf. And that's where that linking comes in. Now, the QMS, again, is designed to assist you, to provide you with reasonable confidence that you are complying with the code. Now, we have had a lot of questions around what constitutes a sufficient quality management system. And something that any board member and the team presenting these webinars has stressed is that we are acutely aware of the differences in sophistication between the big end of town, the big four, the mid-tier firms, and then the smaller practitioners, the smaller firms. So probably most of you online today with under 100 employees, or the sole practitioners. Our expectation is that the big end of town has sophisticated systems. For the smaller practitioners, we are looking for appropriate internal controls to run a practice to ensure compliance with the code. So the internal controls are going to differ significantly between practitioners. Overarching is going to be around the size of the individual practice, but it's not going to be the only thing. It is going to come down to the level of day-to-day engagement by a practitioner on the tax agent services being provided, and also the complexity of the services being provided, as well as the complexity of clients' affairs. And we know, no matter what the size of the firm, various firms specialize in complex issues. So their systems are going to be very different to a firm that provides fairly standard services. What is this obligation designed to achieve? it's designed to give consumers confidence that their tax practitioners have appropriate policy systems and processes to provide tax agent services to a high professional standard. And it's designed to protect you. If there's an issue, one of the first things your professional indemnity insurer is going to do is ask you about your systems in place. So having that in place protects you. For a sole practitioner, which is where we get a lot of questions, that would simply be checklists to ensure the work is done in compliance with the professional code of conduct. You know, what kind of cybersecurity measures do you have in place? You know, documenting your policies and your procedures. It doesn't need to be overly complex if you are at that smaller end of a practice. Our next standard, or our final obligation that I'll go through, is keeping your clients informed. So what this obligation requires is that you advise all current and prospective clients in the prescribed manner and form of the fact that there is a register, that we have a TPB register of tax and BAS agents, and how they can access it and search it. How clients can make a complaint about services provided, including the complaints process, the rights, responsibilities, and obligations, including to your client under laws, and what obligations clients have to you as their tax practitioner. It also requires information about certain prescribed events and matters which have occurred within the last 5 years, and if your registration is subject to conditions. Now, keep in mind a few things here. The obligation is limited to the prescribed events and matters outlined in the determination. So, for example, if your registration is suspended or terminated by the board. So this obligation, it's designed to ensure transparency of the tax profession, which is critical to ensuring the integrity of the tax system as a whole. So again, it comes back to where I started, that whole consumer protection imperative by enabling taxpayers to make informed decisions about engaging the services of a tax practitioner. Now, what do you need to do? The questions that come around this particular standard is what you need to do as the practitioner. So you need to provide the information under this obligation in writing to all of your current and prospective clients in a prominent, clear, and unambiguous way. If you have a website, it could be as simple as making it available on your publicly accessible website that you use to promote your services. It could include having the information in letters of engagement or re-engagement with your clients, or it could include putting in our fact sheet. So we have actually produced a fact sheet that you can give to your clients that provides your obligations, their obligations, and all of this information. Now, there has been a lot of concern around this one as well. We've had a lot of questions around it. And we talk about information in letters of engagement or re-engagement. We don't actually say that you have to provide a letter of engagement. We recommend that you do so. But if for some reason you're not, then it can simply be on a publicly accessible website. Now, that's all I want to say. Julie, I'm going to hand back to you, and Tariq is also going to answer some questions, and I'm getting now lots of thumbs up and no problems here.
Thank you so much, Kerry. That was a really great, good way to start the conversation off today with that really good overview. So as you said, Tariq's going to join us now. So I might give you a little moment to catch your breath, Kerry, and I'll start off with giving a couple of questions over to Tariq. So Tariq, the first one I've got is from Yang Sun, and they're asking, if a client asks us not to prepare formal financial reports, but instead to work only from bank transactions and allocate the balance to directors' loans, what are our obligations under the code determination, and what steps can we take to protect ourselves from compliance or liability risks?
Yeah, thanks, Julie. Good question. So this one probably touches more on the code of professional conduct and not the determination itself. What you should probably do here is have a look at your obligations under the reasonable care obligations. You've got an obligation to take reasonable care to ascertain your client's state of affairs and ensure that taxation laws are applied correctly. Now, that might require you to seek further information from your client. If your client refuses to provide that additional information, you have to make an assessment and a professional judgment for yourself whether or not you're satisfied that you can rely on the information that has been provided. And that will depend on, the nature, like Kerry said, the nature of your relationship with your client and circumstances like that. So there's probably some steps you should have a look at there and have a look at the reasonable care guidance.
Great, thank you for that, Tariq. Another question, which might be a little bit off topic for today, but I think it's still a good one to ask, is from Mark. And Mark's asking, can you discuss the AML slash CTF laws and how this affects the profession? So it might be good if you could explain what that is too, Tariq, just before you get into the detail. Thank you.
Yeah, thanks, Julie. This is quite topical at the moment, the AML CTFs. That's the anti-money laundering, counter-terrorism financing laws. There's new obligations that are coming up in relation to AML CTF that commence from 1 July 2026. This body of work actually falls under AUSTRAC's remit, not the TPB. But AUSTRAC are, we know, running a lot of good webinars on their website. So we encourage you to have a look on their website and enroll into some of those webinars where you can get some good practical information. The TPB will work with AUSTRAC as well to see where there's overlap. And once AUSTRAC have published their guidance, we'll look to do similar things on our end. So you can get some points from the TPB's perspective too. But in the meantime, strongly encourage you to enroll in those free AUSTRAC webinars.
Thanks, Tariq. That's really good to know. So, Kerry, I'll bring you back into the conversation now. I've got a question that's come through from Tim, and Tim's asking, if I become aware of a practitioner's malfeasance where the relevant client is not and has never been my client, what obligations do I have?
Yeah, thanks for that question, Tim. You still do have an obligation because you've become aware of information that is not correct. And basically, the rules apply. As I said, the obligation is to sorry, I'm getting incredibly distracted by all these messages popping up. I need to turn them off, but I've changed my mic and everyone says it's working much better now. So apologies. So your obligation, Tim, would still be to report it and do so in a reasonable amount of time. So it depends on what agency, what the information is that you've got, whether you're reporting it to the TPB or ATO. Tariq, did you have anything to add on that particular question?
Yeah, I can probably just add a little bit on that one too. It's not part of the topic for this webinar, but it might cross over into breach reporting too. So if you've found that another practitioner has breached the code and the breach is significant, remember the breach reporting only applies to significant breaches, then have a look at your breach reporting obligations to notify the TPB of any significant breach of the code.
Great, thank you both for that. Tariq, I've got another question for you now. This one's from Wayne, and Wayne is asking, I would never deliberately make a false statement. However, I have heard that if I put figures in the incorrect item in a tax return, so for example, depreciation, then I could have made one or more false statements. Is that correct?
Yeah, thanks, Wayne. Good question. So as Kerry spoke about that false or misleading statements obligation, it is aimed at false or misleading statements that are material or in a material respect. I think if you've just put something in the wrong field or something like that, you could just correct that statement. It probably is not going to be something that triggers the false or misleading statements obligation. I'd just go ahead and notify the ATO and have that corrected. Just to stress again that false or misleading statements obligation relates to those statements that are false or misleading in a material respect.
I'd second that, Wayne. We have discussed that, and we know practitioners have raised that question with us. And the exact example that you've given us around putting things in the wrong box and whether that's material, if it's not making a material difference to the tax return and the final result, then we wouldn't believe that any action should be taken.
Great, thank you. I've had a few people putting in questions about the fact sheets and getting links to those. We'll share a document following the webinar today that has a whole list of relevant fact sheets and information products as well, so that you'll have that information at hand. Okay, so the next question I've got is asking, to what extent are we required to verify the accuracy of every transaction a client provides? Is there a reasonable threshold or professional judgment standard we can apply short of full verification? Tariq, I might get you to start, and then Kerry, you can add if you like.
Yeah, sure. Thanks, Julie. Absolutely, there's professional judgment is what you'd be exercising here. It's not necessary for you to review and audit every transaction. Like Kerry said, you'll be looking at the relationship you have with your client, past statements that the client may have had. If it's a long-standing client and you've got a relationship with them, you might be taking more information at face value. However, if it's a brand new client, you're dealing with them for the first time, you'd probably be asking a few more questions of the client. So just probably, have a look at the circumstances there.
I'd just add to that. Yeah, just quickly add around proof of identity, which is an issue that comes up frequently. So obviously, when you take on a new client, there's issues around proof of identity, and then we've been asked questions around keeping records. We don't expect you to keep copies of passports, things like that, driver's license, but that's where your quality management system would come into play. Have a checklist on how you have checked POI. And as I said, we don't provide checklists, but a lot of the professional bodies do. So POI is an issue that comes up frequently around that. As Tariq said, when you take on a new client, you're going to be a lot more concerned compared to a client that you're dealing with regularly. Obviously as well, and it's tangential to the topic, but there are issues around cybersecurity, etc. So you do want to ensure that documents are legitimate and that your client is actually your client that you're dealing with.
Thanks, Kerry. That's really relevant and helpful in the current environment, I think. So the next question I have, Kerry, is from Adrian. And Adrian's asking, if a return is lodged and we later realise there is a material misstatement of income, and 2 years has passed since the assessment's happened, how do we rectify this issue when we are unable to amend at that point?
Okay, I'm looking at Tariq here, but correct me if I'm wrong, Tariq, but my understanding is that the obligation is still there. The obligation is one around notifying of the material difference. And someone's posted up, you can lodge a notice of objection. I'll leave that to all the tax practitioners online to work out how you deal with that 2-year rule that's expired, but the obligation would be independent of that. So within a reasonable time, you would be obliged to notify of the false or misleading statement because it is material. It would meet that materiality requirement. Tariq, did you have anything to add on that one?
Just to echo those thoughts, I think, if you are outside a relevant time period to have it amended, the reasonable step would be to contact the ATO and say, look, I've found it's a statement you've made to the ATO previously. You contact them and say, I found a material error in it. and just follow their process in terms of how they want it to be resolved. And I think that would be the practical step. And you've notified the ATO in accordance with your requirements under our provision.
Great, thank you both for that. Tariq, I've got another question now that's come through from Tammy, and Tammy's asking, what about a BAS agent that is an employee? What type of QMS is needed in that situation?
Yeah, sure. Thanks, Julie. Probably just for clarity there, the obligations, all of them under the code determination, apply at the practitioner level, not at the employee level. So in terms of the quality management system, that would sit at the BAS agent level, at the practitioner level. We don't expect, and it's not a requirement for then every employee to also have a quality management system. It's for the employer and the business.
Great, thank you. The next question I've got here is one around questioning whether the ATO is a government agency. So Kanti's asked, is the ATO a government agency and conflict of interest apply to tax agents? If so, all tax agents are in conflict of interest. Why are agents of clients, not the ATO? Oh, sorry, we are agents of clients, not the ATO.
Yeah, I can start on that if you like, Kerry.
Yeah, sure. Yeah.
Unpack that one a little bit. When we spoke about the two obligations, conflicts and confidentiality in dealings with government, I think Kerry made the point that those obligations will only apply in very, very limited circumstances. It's when you're undertaking work for a government agency. So it's, for example, where you might have been contracted by a government agency to do some work for it. Yes, the ATO is considered to be a government agency, but that obligation doesn't extend to, your ordinary course of tax agent services where you're communicating and dealing with the ATO. It's when you've been contracted by the ATO to provide services for it or work for it. So again, it'll apply in very, very limited circumstances. Just wanted to make that super clear.
Anything you want to add, Kerry?
Yeah, we can add some examples there, Julie and Tariq. So we know that the ATO goes out for consultation, Treasury goes out for consultation. So it would tend to be where we have our tax practitioners maybe engaged in, legislative processes or consultative processes, Board of Taxation, ATO, Treasury, etc., in providing confidential advice. So we've seen cases previously where there's been proposed changes to the law and all of that information is confidential. So the kind of situations we're looking at here is where you may be part of a consultative process and you have advanced knowledge of changes to the legislation, and you go back to your firm and you use that information for the benefit of your client. And normally that's going to be financial benefit, but it can be financial or non-financial. So it is very limited, as Tariq said.
Great, thank you. Tariq, I've got a question now about disqualified entities. So it's asking, can a DE provide support services to the accounting practice, not directly dealing with clients?
Yeah, thanks, Julie. Short answer, yes. The disqualified entity provisions are concerned with when the employees or potential employees are providing tax agent services on your behalf. Doesn't extend to support services and administrative services.
Great, thank you. Another question now about incorrect or false statements. So we've got someone asking, incorrect or false statements, report on becoming aware. So that's obviously the obligation that we have. What happens if the TPB decide that someone ought to have known and haven't made a report?
Yeah. So you go, Kerry. Sorry.
I was simply going to say, so that is a breach of the obligation. The obligation is to notify us within a reasonable period of time. So we would then potentially be alerted that you hadn't notified us and decide whether appropriate action should be taken. I think the thing to keep in mind is that we see cases in the media where people's registration has been terminated and there's potentially a perception that that's the only sanction. People get a little worried about that. But as I said, we take a proportionate and appropriate response, and we're here to facilitate the process. So we understand that sometimes people just make mistakes, and we have a range of sanctions, and sometimes it's as simple as a caution letter. People will get a caution letter saying, you should have done this, you didn't. Something else we quite often do is issue notices requiring further education. So we have a CPE requirement, and I know, Julie, you've got a CPE webinar coming up in the next month or so. So if we see practitioners that maybe we view haven't quite understood their obligations under the code, we may say to them, you need to complete certain education requirements, which may be as simple as attending relevant CPE webinars, etc. So it would come down to what kind of level the breach was, and then we would take a measured approach.
Thanks, Kerry. Tariq, did you want to add anything to that?
No, just very quickly, I think Kerry's covered it. The important point there being that the false or misleading statements obligation, it does apply to statements that you know or ought reasonably to know. So it covers both of those circumstances.
Yeah, thanks for clarifying. Okay, the next question I've got here is from Gail, and Gail is asking, she's making a statement first, but just saying, I'm concerned about how these changes will impact sole traders with a handful of clients. I know anecdotally of BAS agents who are insisting that they now become part-time employees rather than independent contractors. Would you speak to that, and anything that you'd like to sort of refer to there would be helpful, thanks.
I'm happy to briefly speak,
Kerry,
and then Tariq may take over. Thanks for your question, Gail. And look, it's the exact reason why we have these webinars, because we know small practitioners with a few employees or sole practitioners are particularly worried about meeting their obligations. Do keep in mind, I know I've said it several times, so I'm probably annoying you by now, but we do take a proportionate and appropriate approach. And as I said, there are obligations to have a quality management system, but for individuals that may be as simple as having checklists. So, and I talked about, proof of identity. It may be as simple as having that checklist saying, when I onboard a client, I go through these steps and meet the requirements under the code. So, in getting information from your clients, it may be as simple as having those checklists. And again, I mentioned cybersecurity. So we're not expecting that these smaller practitioners go out and do exactly what the larger firms are doing. We're finding that a lot of practitioners already have these measures in place. They're doing the right thing. They're just trying to work out how they're doing the right thing. So, as I said, various checklists, and it comes down to professional and ethical conduct. So if you're behaving professionally, if you're behaving ethically, it's unlikely that you're breaching these code determinations. The other thing I will mention is, you remember, as I was going through those 8 code determinations, don't think of them as entirely new obligations. There's always been 16 code obligations. A lot of these 8 just articulate what was already required in the broader requirements. So there was already the requirement to act honestly and with integrity. That's our first code item. So other code items now, the determination is simply expanding on those or articulating them a little more. Tariq, did you have thoughts on that?
I'd probably just echo those comments. We at the TPB are fully cognizant of the fact that sole practitioners operate in a different way to the larger firms, and the way that we have drafted our guidance and published our guidance on each of these 8 new obligations, they're highly scalable. So what will be required of a sole practitioner will be, as Kerry said, much less than what would be required of a larger firm. And we provide practical examples on some of the things that sole practitioners in particular could do in a lot of those documents, particularly, like Kerry said, quality management systems, supervision and competency. There's some simple steps that sole practitioners can take to fulfill their obligations with those requirements.
Thank you. Tariq, I've got a question here from Mohammed, and they're asking to inform clients about prescribed events and matters. Could you please elaborate in a bit more detail, as we are agents supposed to send blogs on behalf of the TPB? I guess they're just sort of asking what kind of things they need to do to notify their client.
Yeah, so thanks, Julie. I think that a couple of elements there, like what types of things might be prescribed events. That's where, if your registration's been terminated, you become an undischarged bankrupt, they're quite serious type of events. There's a full list that we've got there in our fact sheet, but have a look at those. And then in terms of actually notifying your client of these events, you can do that via your engagement letter, via your publicly available website if you have one. And then, like Kerry said, you can make use of that fact sheet that we've published as well on our website.
Great, thank you. The next question I've got is from an anonymous attendee. They're asking, while preparing the tax returns for a client, we are not satisfied with their explanation on some unclear points. They refused to provide further insights and requested us to complete the tax returns with what they had provided, with what was available. Although they sign a letter to confirm they are responsible for what they have provided, detailing what we asked but not yet answered properly, are there any risks that we should be aware of here?
Yeah, thanks, Julie. I can probably start on this one. I think this comes back to that earlier question around, where you're not satisfied about what your client's given you. It's those reasonable care obligations again in code items 9 and 10. You have to make the professional judgment with the type of client you're dealing with. Like I said before, if it's a first-time client, or even if it's an existing client, but you have doubts as to the information that has been provided, our expectation is that you would ask those follow-up questions. And if you're not satisfied as to the veracity or, the truthfulness of the information that has been provided by a client, we wouldn't expect that you just lodge the return on the instruction of your client. You should seriously consider they're declining to act for that client. That would be the expectation of the TPB.
Thanks, Tariq. Kerry, did you want to add anything there?
I will just second exactly what Tariq said. It's up to the tax practitioner to take reasonable care, to ascertain the correctness of the facts provided, and to ask additional questions. And if you're not comfortable as a tax practitioner, then it comes down to professional judgment.
Great, thank you both. The next question I've got is back to upholding and promoting the code that we spoke about earlier in the webinar. You mentioned that there were some practical sort of implementation measures that people can take in their practice. Could you just provide some examples of what that may be? Tariq, did you want to start on that, or Kerry? Sorry.
Yeah.
I don't mind.
Okay, go ahead, Kerry.
Look, I was going to say, so obviously this is what we're talking about in this session. So it's a very broad question in terms of ensuring, you've got everything you need to succeed, to do it all correctly. So I'd reiterate a lot of what I've said around size and structure of your practice. So really focus on that initially, and then drill down and work out what you need to do. So what kind of training and resources do you need to provide your staff with? Do your staff know about the obligations that the TASA imposes, these new code obligations? So, how are you managing underperformance if you do have staff that aren't meeting their obligations? Do you have processes in place for staff to report matters? Are staff aware of the answers to a lot of the questions that we're asking here today? So do staff know that they need to keep records? Are you keeping proper records? So I think overarching, and Tariq may want to add to this, but it really does come down to the size and structure of your practice, and then working out what you need to do to have your quality management system, and then making sure you're implementing that QMS. Tariq, did you have anything to add to that?
I think you've covered that one, Kerry. Again, we've published a lot of good guidance and material there. Have a look at our fact sheet and our information sheet on upholding standards, and we've set out, a full list there of some of the practical measures. So please use those resources.
Thank you. So we've got about 3 minutes to go in today's session. So I'll probably ask one more question, and then Kerry and Tariq, I might just ask if you've got one key takeaway to share with the audience, and then we'll finish up. So the question that I've got now is from Suzanne, and Suzanne's asking, when considering false or misleading statements, what does substantial harm actually mean?
Yeah, look, thanks for that question, Suzanne. What we mean is serious adverse consequences to others. That can be financial, it can be non-financial. We do actually have an information sheet on this that we put out last year in 2024. But what we talk about in that is, things like, you need to consider the rights and obligations under the tax laws. So what is the client doing to fix that misleading statement? If it's a client who has made that misleading statement, what is the practitioner's advice in correcting it? And we've dealt with some of those situations previously. What's the urgency of the situations? So my best advice would be go and have a look at our guidance product rather than me, running out of time, talk through it. But really, it is a question of substantial harm, but keep in mind that can be financial, non-financial, and really look at whether it's caused to the interest of others. How's it affecting other people?
Thanks, Kerry. We'll share a link to that information sheet as well after the webinar
I think
today, so
that'd be
everyone will
really
have it on
useful.
hand.
Yeah.
Yeah, thank you so much. Okay, so let's finish up for today. So Tariq, did you just have one last thing you wanted to give everyone before we leave? Any
Yeah,
key takeaway?
I'd probably just reiterate the point that Kerry made earlier. These are 8 new obligations we've spoken about today, but they're very consistent with your existing obligations under the Code of Professional Conduct, relating to, honesty, integrity, competence, confidentiality. So in a lot of cases, practitioners will already be doing these things. They might need to make some minor tweaks to come up to speed with the new obligations, but just want to reiterate that, yeah, they're not brand new obligations, and you'll be able to leverage off the systems and processes you already have in place in your business.
Great.
And please use our fact sheets. We've recently published 8 new fact sheets. They're 1-2 pages each on each of these obligations. They give a really great snapshot of what you need to do.
Excellent. Thanks, Tariq. And Kerry, last word from you today?
Last word would be to keep engaging with the TPB. We run lots of webinars. We have different presenters, and we have those fact sheets. I know everyone is time poor. We're doing our absolute best to ensure the information is concise, and those fact sheets that Tariq had talked about, we've been working on those so that you're not having to read through huge amounts of paper. But then, as I said, we've got webinars coming up on CPE obligations, etc. So we do want to set you up to succeed, and we don't want to impose unnecessary administrative burdens on you. So it is a case of being proportionate and appropriate to your circumstances.
Great. Thank you so much. That's a good point to end on today. Just quickly give you some information on how to stay in touch with us. So if you'd like more information, as we've said today, just jump onto our website at tpb.gov.au. You can also follow us on LinkedIn and Facebook for our most up-to-date information. We also have an e-news, which is our newsletter that goes out each month. I would highly recommend that you subscribe to that because, again, that's the most up-to-date and relevant for you. You can also subscribe to our YouTube channel. And if you do so, you will receive notifications when we post new videos. We do record all of our webinars. And as you probably know, we've got a very comprehensive library available there. And you can view those anytime and still claim CPE for viewing those. So I just wanted to finish up by saying thank you so much to both Kerry and Tariq for sharing their insights today. And thank you to our audience for attending and sending through your great questions. It was a really, really informative session. And we do hope that you found it beneficial as well. If you're interested in attending another webinar, again, just jump on our website at tpb.gov.au/webinars. And we do have another one on today if you're interested in coming along, which will be on whistleblowers, which will be joined by the ATO as well. So if you're available, jump onto that this afternoon. And finally, just before we do finish, we'll be launching an exit survey, and that just pops up in your browser when you leave the webinar today. And we would really appreciate it if you could just take a moment to complete that to give us any feedback or topics that you might be interested in hearing about from us. So thank you everybody for joining, and we do hope that you enjoy the rest of your day. Thank you.